Welcome to the fresh episode of Legal Wrangle, where we will track major judicial developments in the realm of domestic taxation. For this, we have selected three important cases. First, where registration was denied to a charitable trust because it has not commenced any activity. Second, where levy of interest under section 220 subsection 2 was disputed in the case where taxpayer had opted for Kar Vivad Samadhan Scheme. And third, where section 50C was invoked in case of transfer of leasehold rights for 99 years in a shop. The issue in our first case arises from the denial of registration under section 12AA, entirely on the ground that no activities had been undertaken by the trust before the application of registration was made. However, when the matter was listed before High Court, it was held that in case of newly registered trust, even though there was no activity, it was possible to consider where the trust can be registered under section 12AA.
Let's see what the final outcome of Apex Court was. The purpose of section 12AA is only about registration of trust and not to assess what a trust has actually done. The expression activities in the provision of section 12AA refers to proposed activities, and therefore registration cannot be denied if application is made prior to undertaking charitable activities.
Now, let's move on to a second case, where interest under section 220 subsection 2 was levied on taxpayer while issuing certificate under Kar Vivad Samadhan Scheme. Though the taxpayer contested the levy of interest, the interest amount due was paid nonetheless. However, later on, RITZ court was approached seeking that the duty payable under the scheme be redetermined after excluding the interest component.
Let's see what the final outcome by the High Court was. The notice of demand under section 156 contained a provision informing the concerned taxpayer that if he did not pay the amount within the period specified, he would be liable to pay simple interest at 1.5% for every month or a part of a month from the date commencing after end of the period in accordance with section 220 subclause 2. While processing an application under the Kar Vivad Samadhan Scheme 1998, the designating authority is empowered to add up interest under section 220 clause 2, which hitherto was not quantified.
Now, let's move on to our last case, where the long-term capital gain claimed by the taxpayer came to be denied. When asked as to why the value adopted by the stamp valuation authority shall not be considered as the full value consideration for the purpose of section 50C, the taxpayer produced a calculation of capital gain and stated that in view of the fact that only the leasehold right in the land has been transferred and it is not a transfer of land or building or both. His case did not fall under the purview of section 50C. The AO, however, rejected such plea.
Now, let's see what the tribunal had finally decided. Provisions of section 50C cannot be invoked if taxpayer has transferred leasehold right for 99 years in shop and not land itself. As section 50C applies only to a capital asset, being land or building or both, it cannot be made applicable to lease rights in a land.
With this, we wrap up this episode of Legal Wrangle. Until next time, keep watching TIOL Tube for our upcoming episodes. Thank you for watching. Goodbye.